Well, yes. So, good morning, everybody. It's great to have you back with us for our third webinar of the series Explore Doing Business in the Netherlands. This morning, we'll be breaching on the legal aspect of having a business in the Netherlands. Let me quickly remind you, Explore Doing Business in the Netherlands is a week-long event of webinars organized by NRCC, Netherlands Romanian Chamber of Commerce, the Netherlands Embassy in Romania, and the Romanian Embassy in the Netherlands, DRN, Dutch Romanian Network, and NLinBusiness. And we enjoy the kind support of Dentons who host us on their platform. Today we have with us as speakers two counsels from Dentons. They're going to talk about starting a business in the Netherlands. Their names are Bram Bloemers, counsel with Dentons, and Doru Postelnicu, also counsel with Dentons. Before I leave the floor to them, let me quickly remind you, please keep your mics closed at all times when you are not joining in the conversation. We have after the presentation, we're going to have a Q&A section, and any questions or remarks or observations you might have, we can discuss them then. If during the presentation you want to ask something, please type your question in the chat, and when we get to the Q&A, we will read it out loud and answer it. Without further ado, I wish you a pleasant webinar, and I leave the floor to Bram Bloemers.
Good morning. My name is Bram Bloemers. Thank you for the introduction. I'm a Deputy Civil Law Notary at Dentons. I'm counsel at Dentons, and I work in the corporate area. This means that we do simple incorporations of BVs and NVs in the Netherlands, but also listings or other forms of exits or buy-ins. And we provide assistance on, for example, joint venture agreements and the implementation of joint venture arrangements into BV articles of association. Today I'm going to bring you into detail of starting a business in the Netherlands, the incorporation process, as well as the several legal forms that we have. And I'm going to take you in a bit more detail on the flexibility and the reasons why the Netherlands is such a helpful jurisdiction for foreign entrepreneurs to structure their business via a Dutch company. If we can proceed to the next page, I will briefly discuss the NV and the BV. The NV is a public limited liability company, as well as the BV is a limited liability company, while the NV is basically often used for listed entities or the really larger entities or banks or insurance companies. The BV is typically a privately owned company, having added a lot of flexibility in the last years via new legislations that is not one-on-one applicable to the NV. So if you're looking for a flexible structure, usually the BV is the entity that is chosen by the shareholders and the entrepreneurs. If we can go to the next page. We have, of course, other legal forms that we use in the Netherlands. We have the larger European company, the SE, Societas Europea, a cooperative. Usually that was for farmers, but we also see that nowadays in more detailed holding structures with two partners or members of the cooperative. The partnership under Dutch law, that is not a legal entity, but is more of an agreement between two entrepreneurs to share profits and to cooperate. The more specific form of a partnership is the limited liability company, or the CV. That is actually a partnership with one of the members, not being disclosed to the public. And we have the foundation, the stichting, that I will discuss at the end, which is very often used to protect the shareholder structure, to assist in tailoring the governance of certain structures, depending on the specific needs of the structure. If we go to the next page, there are some differences between establishing a BV and an NV. We will discuss those differences. We will discuss the articles of association, the shares, the corporate bodies, the adoption of the annual accounts, and the liquidation process. Mostly it is very similar, but if you go in further detail, we will learn that the BV is much more flexible than a more static NV, with strict rules whereby at BV level almost everything is possible in the Netherlands. We will provide an overview of those flexibility rules, whereby the basic rule basically is everything is possible unless you go into tort or something that is never meant to be. For example, you cannot be a shareholder if your shares do not grant any profit nor any voting right. But it is possible, for example, to have shares with only voting rights or only a right to profits. That is at the BV level. At the NV level, that is not an option. For joint ventures, we have the shareholders agreement in relation to the articles of association. We can discuss some governance and minority protection rules. And we will briefly discuss some corporate law issues. We see that on the next slide. Where we have the general corporate law issues, the shareholder liability, which is hardly ever safe in cases of tort. I will explain that later. And we have a limitation of liability via the so-called 403 statement that facilitates the ease of adoption and drawing up of annual accounts, but in return requires a shareholder liability, or at least a parent company liability. These first pages are basically provided for general reference. If we go to the next page, we will end this brief introduction with you can read, and we'll come back further. The reasons to use Dutch entities in general is a neutral forum, as the Netherlands has a very well legal system with neutral courts. The manner of conflict resolutions to be tailored, either Dutch law, foreign law, possible in a shareholders agreement. You can have an arbitration clause, or you can choose the Amsterdam court. We have flexible corporate law, at least that is for the BV. Both the BV, the NV, and the cooperative may provide for limited liability of the shareholder. You have bilateral investment protections. That means that your investments are safe in the Netherlands. We have a decent manner of tax structuring with certainty upfront. And we have no access limitations, which basically means that other than as you are an individual, if you want to have your enterprise run through a Dutch BV, NV, or other legal entity, that is possible. The Netherlands does not prohibit the entering of those companies into the Netherlands, and you need no permit. Besides that, we have, of course, the partnership, which is an agreement. Even if you are abroad, one could choose to have Dutch law partnership and sign a Dutch law partnership agreement abroad, outside the Netherlands. We have the cooperative, and we have the foundation. And all those in itself may form solid reasons to choose the Netherlands as the jurisdiction for the structuring of your enterprise, or the entire group as a holding company in the Netherlands. Then we'll go to the incorporation process of the BV and the NV in the Netherlands, because both require a notarial deed in the Netherlands. So it's not a matter of exercising your right as a person or legal entity by just downloading a form online, signing that. That does not help you to get an enterprise in the Netherlands. You need to go to a civil law notary in the Netherlands, and he can prepare, like in many other jurisdictions, a deed of incorporation, which is executed by the founders, that upon incorporation will also take shares, and so after incorporation will become a shareholder in the BV or the NV. And by having a shareholder, you have the general meeting, you can exercise voting rights therein, and if you want to take out the funds contributed or generated in the company, from a European perspective to the NV, we have strict capital protection rules, such as for the NV, a requirement of minimum capital, which for the NV is 45,000 euros, while the BV has a minimum capital of 1 cent, basically, which do not need to pay up. It only needs to be paid up once the company requires to pay up that capital, while at the NV must be there upon incorporation, the minimum capital of 45,000 euros. Also certain formalities on payment of shares at the NV for a contribution in kind. For example, an auditor statement is required upon incorporation to certify that the shares are actually paid up. For example, if you would transfer real estate assets as payment on shares, an auditor would need to declare the minimum value of such assets.
If I may add here, this aspect that you mentioned with the share capital that doesn't have to be paid up front is a big advantage, because in Romania we have this difficulty where the minimum share capital is 200 RON, maybe some 40 euro for a BV equivalent, SRL, and this must be paid up front with the bank. And in case of foreign shareholders, this is very difficult to do it in a fast way, to open the account, because of the bank checks of ultimate beneficial owner of the accounts, know your customers. So in practice, this takes a lot of time in Romania, and there is currently a draft law in the parliament which would make it possible to open a company without this share capital upfront, which is a great advantage and speeding up the process of incorporation. It's very nice that such things exist in the Netherlands.
Yeah, for the NV, basically, it's difficult. For the BV, it's easier indeed, because we have that system whereby the funds may be paid up at the later stage. We do, however, and that must be disclosed, find the same issues on our way to opening a bank account, because banks in Europe are very strict. So even though the process of incorporation can be, for example, a one-day operation, if everything goes smooth, and the amount can actually be paid up in a different bank account for the risk and benefit of the BV, but that still has the challenge in it that the BV itself, even after its incorporation, may find certain difficulties in getting a bank account opened in its name. And the reasons therefore are twofold. First of all, banks have a huge backlog in following new European regulations after the financial crisis, in identifying all their account holders. So they're basically working on that. And therefore they do not have the manpower available to speed up a very difficult new process in knowing your customer. And yeah, therefore also in the Netherlands, unfortunately, it may take a while to acquire a bank account, but the good news is that does not pose any hurdles to the incorporation of the BV. For the NV, we have the financial assistance rules, probably also known in Romania, and strict rules on the distribution of dividends and reserves, whereby such distribution is only possible to the extent that those reserves are larger than the minimum capital and other legally required reserves. If not, distribution is not allowed. We go to the next page. So as said, the BV is a much more flexible instrument. We have limited rules on capital protection. They are still there because there is a rule, and that is that the BV must be able, after a distribution to its shareholders, to continue to pay its due debts for at least a year, but a reasonable period. So it's a bit of an open end, but that's the only material test that needs to be done. You need to have sufficient equity, and you need to be able to continue to pay your due debts. That's not the BV in theory could, even if it has a high capital, it could even distribute part of that capital with shareholders. And we have the possibility to incorporate detailed shareholders arrangements in the Articles of Association. It is even possible to refer to, for example, a shareholders agreement in the articles. And have quality requirements for shareholders, for example, that they need to be a party to the shareholders agreement. That means that if, for example, a shareholders agreement provides that it is possible that a shareholder must exit from that agreement for any reason, for example, material default, that would also mean that it would, by law, be obliged to transfer its shares in the capital of the BV, and to the extent it does not do so, the rights as a shareholder to the distribution of profits and, or for example, voting rights are delayed.
Worth mentioning that in Romania, rights of the shareholders are regulated in a very restrictive manner. So in Articles of Association, we cannot fully derogate from the law. And for example, in case we have several investors which have contradictory interests, they cannot have their agreement fully implemented under Romanian law. For example, their voting rights. The majorities for taking decisions in shareholders' meetings are mandatorily provided by the law. So the parties, somebody can always take a decision even though their agreement was to act jointly, only with 100%. Because in a second convening, for example, decisions can be taken much more easily with the majority of whoever is present. And for that reasons, since I ever remember, so since I am a lawyer, we have advised the clients to use a joint venture structure under Dutch law, because our understanding is that there you can have whatever the parties' agreement is, that will be upheld by law and will work under Dutch law.
In any event, because of all these flexibility rules, we see that the BV is mainly used for structuring joint ventures, because at the end of the day, in joint ventures, what we often see is that first the shareholders lay down their agreement in writing with the help potentially of a Dutch lawyer. And on that basis, we as notaries review the shareholders agreement and the arrangements that parties want to make. And for example, if we assist a minority shareholder, the minority protection rules of the shareholders agreement can be included in the Articles of Association. And it is good to know that the Articles of Association, probably like in Romania, are always filed with the Dutch Trade Register, and therefore they may be reviewed by third parties. So that means that third parties can take knowledge and will take knowledge of the protection rules. For example, if the board needs the prior approval of the shareholders' body, the general meeting, for certain divestments, minority divestments or larger divestments, third parties will know that. And a notary in the Netherlands involved in such a transaction, he will review the articles and he will say, hey, guys, this is what you decided, but I learned from the articles that I just reviewed that you require, for example, shareholders' approval with a certain minimum majority, like 80%, or with at least 50% or 60% of the issued share capital represented in the meeting. Can I first see that everybody is in agreement, and then we will proceed with that transaction. So that is basically helpful. We can go to the next page. We have the it is good to mention just the incorporation procedure as a brief outline. At the end of the day, notaries will always be involved in the incorporation process of a legal entity in the Netherlands because it requires a notarial deed of incorporation, which contains the articles of association. For a BV, although no required minimum paid-in capital is needed, you should think about what is a logic capital, especially in case there are more shareholders. We have a deed of incorporation that reads in Dutch, so an English translation is needed. The good news is that may be an office translation, so i.e. an informal translation provided for by the notaries, and we do not need like an authenticated translator with apostille, etc. But the deed still reads in Dutch, and the Dutch deed is filed with the Dutch Trade Register. After incorporation, the shareholders of the company are laid down in a shareholders register that basically, which is a booklet, hard copy booklet still. Electronic copy is possible, and that booklet mentions the number of shares. It mentions whether there are pledgees on the shares, and it is signed by the board and kept by the board of the company. And if a share transaction is contemplated, that original booklet is always sent to the notary for review, first of all, to see if the shares are pledged, who holds the shares, and after a transaction is effected, the notary updates the share register, sends it back to the board of directors for signature. We file the BV with the Dutch Trade Register. What do we file? We file the name of the BV. We used to file the directors with all their personal details, including their private address. That private address is no longer visible. So you only see the names of the directors, the name of the sole shareholder, if there is a sole shareholder. And rather new since this month, we have the UBO register, which is based on European regulation, and that goes a bit further than we like in the Netherlands, to be honest. But on the basis of the UBO register, which is a public register, which can also be reviewed by journalists, unfortunately, we need to file the ultimate beneficial owner. So that may be most logical, the real beneficial owner, the person or persons that hold 25% or more of the economic rights, but also persons with the voting rights must be filed there, if provided they have more than 25% of the voting rights in the company. If you are talking about a listed company or a company that does not have any shareholders with more than 25% of the shares, the factual UBOs need to be filed, and those are the managing directors. So that is important to take into account what becomes public after incorporating a company in the Netherlands.
We have the same procedure also in Romania this year. This UBO register has been implemented. The deadline for filing in for pre-existing companies has been postponed several times, so the time is still ticking for filing this information. And indeed, for new companies, it's a pain in the ass to provide them, especially when we have the final holder being some fund, foreign fund. It is very difficult to clarify with the trade registry who is actually the person behind, because the purpose of many of such funds are to have the persons as anonymous as possible. So yeah, it's a difficulty also in Romania.
As far as I'm concerned, we can go to the next page that briefly sets out the items that are covered in the Articles of Association. I think it's quite self-explanatory. I will pick out a few. It will, of course, contain the name. Let's say it's a BV. It has the name of the BV and it starts or ends with BV. It has a seat. The seat is always in the Netherlands. So you cannot have a seat in another place. The office address can be there. I just lost my sheet.
Sorry, apparently I have an internet glitch, but it should be, yeah, it should be up again now.
Okay. Not with me, but I have my well, okay, I'm still at the Articles of Association sheet. I think I lost. Am I still? Can you still hear me?
Yes, we can hear you and see you, and the presentation is on this.
Okay. It has the seat, which must be in the Netherlands. It provides for a general objects clause, can be very specific. It provides for the number of shares, the way shares are paid in. A more important clause is the way shares are transferred. It's possible to include specific transfer restrictions in the Articles of Association, which is namely interesting if you have, for example, employees participating, because I just noted that if you have, for example, a joint venture, you can have quality requirements that a party holding shares can only be allowed to hold shares as long as it is a party to a shareholders agreement. But you can do a similar thing, for example, with employees that are granted shares in the capital of the company as an employee benefit plan, basically. You could, for example, grant them, let's name them employee shares. It's possible to provide that. And you can say, well, as a quality requirement for holding employee shares, a person must be employed by the company. Which means that if for any reason the company no longer is employing that person, he has to transfer his shares to the company. And the value, fair market value or other value, can be included in the articles, depending, for example, on the reason why such employee has to transfer his shares. If he has fulfilled all his duties for many, many years and he just retires, he can get the fair market value. But let's say he is subject to fraud or performed an act of tort or maybe even a criminal act, you could include that he has to deliver the shares against payment of the nominal value only. So, of course, that may be included in the manager's participation scheme, but part of that may also be included in the articles to make it even more thorough. The arrangements with those employees. We can choose and we cannot choose because we need to have a management board and we need to have a general meeting. The supervisory board for small companies is optional. And you can have all kinds of arrangements with respect to the amendment of the articles and the adoption of the annual accounts. I go to the next slide. The general meeting basically has all the corporate powers not granted by law or by the Articles of Association, such as the most important ones: appointing managing directors and or supervisory directors, amendments to the articles, which is typically a shareholder thing, adoption of the annual accounts. The annual accounts are prepared by the board, but the general meeting adopts them, and the decision to actually seize the company and liquidate the company. And all those resolutions may also be stipulated in a further way. For example, it is possible with the BV to have a shareholder A only appoint the director A and only dismiss the director A, and have different types and classes of shares providing for various specific powers within the company. And by doing so, the checks and balances within the company can be very much tailored at the level of the BV. I go to the next slide for the annual accounts. Well, that's quite self-explanatory, but they must be drawn up within 5 months after the end of each financial year, and the management board is the corporate body that actually draws up the annual accounts and then presents them for adoption at the general meeting. Usually, or very often, that 5-month term that I mentioned is not sufficient, in which case you have another 6 months possibility to lengthen that term. And if you're not in time, the board of managing directors may be held liable in case of bankruptcy. So it is important to prepare those accounts on time and to have them presented to the shareholders body on time. And that is also an important thing to note. The shareholders body, the general meeting, has the right to information of the company, such as the information that is included in the annual accounts. But the general meeting, the shareholders are not the board. And that is a specific thing of Dutch law, that each shareholder, provided it has a sufficient stake in the company, may request in a general meeting the board for information. But outside a general meeting, that is only possible if that has been agreed with the board and the company. And therefore, we very often see in a shareholders agreement with respect to a joint venture that it is specifically agreed that a shareholder has the right to information and request information and go to the company to look into the books and the records of the company to see what's going on. Because by law, it is important to realize that is not an automatic right, and that right is only there in an actual physical general meeting of shareholders, which means that's basically, to the extent not specifically convened, only once a year at the moment of the adoption of the annual account. So in general, especially with joint ventures where the shareholders are the biggest funding parties, it is a very good idea to enter into a shareholders agreement to provide for items in addition to Dutch law, such as the right of information. Let's go to the next slide. And then again to the next slide, because I want to skip this item in view of timing. I think it's good to discuss the further flexibility with respect to the BV that was introduced only a few years ago. Number A, the transfer restrictions that are optional. A few years ago, prior to 2013, transfer restrictions at the level of the BV were mandatory, i.e. it was not possible to transfer shares unless either there was a corporate body or 2 corporate bodies that had approved the transfer, or, for example, if there was an offer clause included in the articles, it was only possible with respect after a first offering had taken place by one shareholder to the other shareholders. It is now possible to make that much more flexible. First of all, you can take the whole offer clause or approval clause out entirely. So you're free to arrange it in a shareholders agreement. If there's no offer clause included, that means parties are freely allowed to transfer their shares, perhaps subject to an arrangement in the shareholders agreement. But it's also possible, which was previously not the case, for example, to enter a lockup period of 3 to 5 years for startups. We see that very often where people are funding, that there is a lockup period not allowing shareholders to transfer their shares during that specific defined period in the articles. The lockup period can, for example, also only apply to the, for example, only to the shares of the founding shareholders. So one could grant the founding shareholders shares A, subject to a lockup, while investing shareholders would have shares B and or C of another class with no transfer restrictions at all. It is possible, subject B, to include non-voting shares and shares without profits rights. As said, it is not possible to have both, a share that does not give voting rights and has no profit rights, but who wants to have that anyway? The combination of all those things is possible, and that allows for a lot of flexibility. For example, accepting a funding shareholder without him granting a thorough right of voting on his shares, so that he does provide funds but has no say in the company, or like the other way around. You have instruction rights for shareholders, sub C, which means they have the right to instruct the board to act in a specific manner with respect to the policy of the company. You can grant a shareholder, sub D, direct appointment rights. For example, if he wants to appoint his own managing director, the articles may provide for that, and that director may not be dismissed by another body unless the articles explicitly provide for that option. As said, the shareholders may be required to meet qualitative requirements, such as being an employee of the company, such as being a party to the shareholders agreement, or living like within 30 kilometers from the company. You have shareholder rights that may be suspended if those qualitative requirements are not met. You have the lockup obligations that I just discussed. You have, if the shareholders' rights are suspended, also the voting rights and dividends rights may be suspended. We can have a functional currency, for example, US dollars. We have new rules on distribution of dividends, whereby it's much more flexible, and basically the responsibility lies to actually make the payment lies with the board, while the shareholders' body would decide on distribution. We have no longer minimum capital requirements for the BV. We have all the flexibility on transfer of shares, provided, however, that a notarial deed in the Netherlands is required. And we can provide for a one-tier or two-tier board to basically align with the system that is more known in the US. Yep.
It should be said that what you presented before this flexibility in March, it is not available in Romania. For example, transfer of shares must be approved by a majority of shareholders specific for the Romanian BV SRL. There have been further restrictions which have been repealed 1 or 2 months ago. For example, there was a 30-day waiting period for transfer of shares outside the company, which led to complications in case of M&A transactions. And there was also a limitation for chaining, where a sole shareholder could not, a company held by a sole shareholder could not be a sole shareholder in another company, which led to the situation where you had companies held by 2 shareholders, one holding 1 share and the other one holding hundreds of thousands or millions, just for as a formality. So this aspect of with flexibility of transferring of shares, it's a huge benefit, I believe. Thank you. I believe Bram was.
Yeah, he's
out. Welcome back, Bram. I think you dropped for a moment.
Yeah, I hope you were able to fill the few minutes.
Yes, thank you.
Okay, very good. Well, that is basically a brief overview of the flexibility that we have, and that flexibility, of course, and then of course we go to this next page, is very appreciated by joint venture partners, because like 10 years ago it was also flexible and possible, and we could do, at the end of the day, we came a long way. But now it's really possible under Dutch law to tailor the articles of association to the exact needs of joint venture partners. So it makes our life much easier. From a legal perspective, perhaps not even always. Sometimes it's too easy because we can do almost everything. So we just have to write it down in the manner that people actually desire their needs. But yeah, we're flexible, and the good news really is that with that flexibility, we can tailor to the needs also of, for example, minority shareholders, or the other way around, the majority shareholders, depending on who we're representing in a specific case. I'm able to go to the next page. Well, for example, as said, sometimes it's desired to protect the minority shareholders, and sometimes it's desired not to do so. So it depends on the needs, and we can do that. Next slide, please. Are there no issues? Yes, there are issues. We have directors, and they have a responsibility. They have a responsibility, for example, in the determination whether it's a good idea to distribute dividends to the shareholders. And that can sometimes bring a conflict between shareholders and the board, where the shareholders say, of course, I want my money, while the board of directors says, well, sorry, we did this liquidity test that we're required to do so by law, and we think the amount that you resolved on as a distribution is a bit too high, and we can only go as far as half of it. The board of directors has to prepare the accounts. They have to do that on time and present them on time to the shareholders' body. The board of directors needs to make sure that taxes are paid and filed with, and they should not perform acts of tort. We do provide for the possibility of having a director legal entity. So yes, it's possible, for example, to have a governance foundation whereby the governance is exactly tailored to the needs of the shareholders as a director legal entity. But it should be noted that at the end of the day, Dutch law always provides that the individual being a director of the shareholder director is the person that is liable in case liability is found under the laws of the Netherlands. Ready to go to the next slide? Shareholder liability, we have that, but not as a general rule. In general, shareholders are not liable. They only can lose the amounts they funded or are required to fund according to the articles as they established at the end of the day themselves. There's one exception, and that is the exception of tort. For example, if a shareholder decides to distribute dividend while it knows or should have known, despite the board doing the liquidity check that is incorrect, that such a distribution was not a good idea, they may be held liable through tort. But then, of course, we deal with bankruptcy situations in which the liquidator or the administrator of the bankrupt company will have to prove such act of tort from the shareholder.
We have also, under Romanian law, I believe this is a general exception, so-called piercing the corporate veil, where the shareholder would use the assets of the companies as his own assets, and therefore it becomes apparent that the company and the shareholder are actually the same entity, and the legal form is just a frame. And in that case, it is possible that the shareholder is liable for such deeds where the patrimonies of the company and the shareholder appear to be mixed. Thank you.
Not again. I'm ready to go to the next slide. Yeah. So basically, I'm summarizing again the reasons to use the Dutch entities, the NV or the BV. The Netherlands is a neutral forum. We have the possibility of contract level resolution through arbitration or through the Amsterdam court, which is specialized in corporate conflicts. We have a very flexible BV law. We still provide for limited liability for the shareholders, save in case of tort. We have bilateral investment protection, very generous tax restructurings, and we have no access limitations. So if you want, you can always incorporate a BV or an NV or another legal entity in the Netherlands and become a shareholder. Ready to go to the next slide. whereby I will discuss some other legal forms. The partnership is basically just a contract between parties. It's between the, in such case, they do not become the shareholder. They do not have any a legal entity. It's just a contract. So, for example, in such case, assets are owned in the name of the partners themselves and not in the name of the partnership. That's a big difference. For example, if you're seeking capital protection or if you are seeking limited liability, a partnership does not provide for such things. But it is, however, possible, for example, between joint ventures to both have a BV and then establish the limited liability, and with the BVs enter into a partnership agreement. I will leave this, given the time we have left for this presentation, as is. It's good to know that we also have other different legal forms. We have the cooperative. It's just another animal within the Dutch possibilities. It is quite flexible. Sometimes it's advised to use that from a tax perspective. In the old days, the cooperative was typically used by farmers who jointly, for example, have lands and then go to the market and offer their goods in the market. At the end of the day, the description of a cooperative is also useful in corporate structures. It's a bit far sought sometimes, but it still happens that certain companies request this cooperative. I'm ready to go to the foundation, I think, which is the next page, I think. Yeah, the foundation is something, it's called a stichting under Dutch law. And it is also an entity that is formed by notarial deed. But the foundation does not have any members or shareholders. And that makes it usually an entity that is used solely for governance and structuring purposes. The Dutch foundation is really ideal either to protect your structure from hostile takeovers. For example, a foundation with a certain governance can hold preferred shares that at the moment a hostile takeover occurs gets all the voting rights in the BV. So then if you control the way the foundation is governed, and that then can be completely tailor-made to the specific needs of the client, then you control the company. And what we very often see is a foundation used in the Netherlands, and that I want to mention for estate planning purposes. For example, the foundation can be the shareholder. And if the foundation is the shareholder, the governance of the foundation can be tailored completely. That means that if you want to grant shares to your children, while you do not want your children to have any voting rights until they are of a responsible age or had the proper education to run a company, you can determine that the voting rights of the shares are held by the foundation, while the economic rights of the shares are held by the children. And if the voting rights of the shares are held by the foundation and you have tailored the governance of the foundation to your specific needs, there is no way that the kids can claim that they want to get those voting rights. And it is even possible to say, well, if I'm not there anymore, the board of the foundation will be established as such, or these and these persons will be authorized to appoint the board members of the foundation. And in that way, it is a very efficient and thorough manner to divide the voting rights with the economic rights to a company. And so therefore we see the foundation being used a lot in the Netherlands for estate planning purposes. The foundation is just as other legal entities incorporated by a notarial deed in the Netherlands. And that deed includes the name of the foundation, the purpose, for example, estate planning purposes, the method for the appointment and removal of directors. So the method must be included, but the way it's done is almost at the liberty of the incorporator. the municipality in the Netherlands where the foundation is established, and the use of the surplus after the foundation. And that is important because the foundation itself has no shareholder or member. A surplus must go to, if any, must go to, for example, the zoo or another beneficial manner. But that does not harm, because what we do in the Netherlands, we grant the economic rights of the shares to the depositary receipts holder, and those depositary receipts are issued by the foundation, while the costs of the foundation are paid by the company, and the foundation itself will never acquire any assets, because if the shares are being given back to the depositary receipt holders, the foundation will have no equity. So even though Dutch law provides that the articles of association of the foundation must provide for a rule how the equity of the foundation is distributed, a foundation that is used for governance perspective never will have any equity, so don't worry about that. And again, once we've done all that, the foundation is incorporated by notarial deed. I come to the end of the presentation. And I think it's 5 minutes before time, right? So it should be good perhaps to see if there are any questions, or whether Doru would like to add.
This I managed to cover during various interventions, these recent changes in Romanian companies law. So no need to stay with this. Let's move to the Q&A.
Thank you for the presentation and for the explanation. We didn't receive any questions per chat, but if any of our participants would like to ask you something, by all means, unmute your mic and state your question. Our speakers are here to answer. Any detail, any thing that caught your eye or your attention? Of course, should you think of anything after we close the webinar, just drop your questions in an email to the NRCC, and we'll make sure to put you in contact with the speakers and to get you the answers. Until somebody decides to break the ice, Doru, maybe, or Bram, maybe you would like to add something to your presentations?
I'm very fine in what I told. I do see one question.
Yes.
Coming in.
Yeah.
What advantages has a holding company that holds shares of Romanian companies? Well, that's what we often see in the Netherlands. Right now, to be honest, I'm doing a listing whereby a German company has incorporated a Dutch company that will hold all the shares in the German company, because the market is used to a Dutch company being the NV that is listed on that particular stock exchange. So the advantages can be numerous. Sometimes it's a flexibility people are looking for. Sometimes it's the neutral court people are looking for. Sometimes it's the reason you want a Dutch holding company for tax restructuring, taxations, for example. So yeah, it depends on the specific situation.
For example, it may have been mentioned in other presentations that the biggest investor in Romania are the Netherlands, but not because the Netherlands invests money in Romania, but because the instrument used by foreign investor, irrespective of the countries, is most of the time a Dutch company as a holding company, especially because for the reasons we mentioned, namely flexibility, over and over flexibility, but also the existing double tax treaty. I see that somebody asks about this. So there is a double tax treaty in between Romania and the Netherlands, very advantageous. So these are the reasons: flexibility and double tax treaty. So I believe maybe 70-80% of the transactions that I see foreign money invested in Romania is done through a Dutch instrument.
I have shared on screen both your details for those interested to get in contact with.
Thank you. I think it's now a good time to wish everybody a pleasant day.
Yes, I think we can wrap this up here. Thank you again, Bram Bloemers and Doru Postelnicu from Dentons, and thank Dentons for hosting us on their platform. Thank you all for taking the time to be here with us today, and don't forget to log in for our next webinar this afternoon. We're going to talk about how to organize your workforce in the Netherlands. The starting time is 4 o'clock Romanian time or 3 o'clock Dutch time, depending on where you log in. Until then, have a productive and very good day, everybody, and see you at our next webinar. Bye-bye.
Have a
Thanks.
nice day.
Bye-bye.